and people conform, there must be law and order. Law and order help shape the character of any nation, our people, and our government. Hence, the need for the judiciary to guide in interpreting laws so the society can be orderly. For ages, the judiciary has played roles in defining laws and helping set standards that unfold and lay bare critical legal issues all around the world. In Nigeria, the judiciary as an arm of government and over the years have served as the last hope of the common man, interpreting laws to give direction and order many true policies that guide the other arms of government. But lately, citizens have lost trust in the judiciary because of some controversial judgments that has laid foundations for tyranny, corruption, and affected critical areas of life as a Nigerian in Nigeria. This documentary, therefore, is an expose to shed light on issues surrounding the judiciary with special focus on the Supreme Court. The preamble will give definition of terms, types of courts, how they are constituted, sample of judgments, and how these judgments affect the judiciary and how it shapes our society. It will be in 2 parts.
Well, I'll be frank, I don't have any faith in the Nigerian judicial system, and the Supreme Court being one of them. I don't have any faith in the Supreme Court either. And my reason is founded on the fact that I don't have any faith in the government, in the system, in the elites that currently rule us. And that's the reason why I don't have any faith in the judicial system, because corruption has seeped into every aspect of the Nigerian government. It doesn't matter if it's the law enforcement, that's the police. It doesn't matter if it's the army. It doesn't matter if it's the federal civil service. The level of nepotism that just takes place and impunity is just blatant. So it's left for us to see. And another reason I say this is because I'm one of those that advocates that the current judicial battle between the Labour Party of Peter Obi, APC, and INEC should be aired real time, so that the people can get to see how these proceedings take place. I don't feel it's something that should be hidden. I feel it's something that should be opened, it's something that should be analyzed, so that we can all get to understand and see for ourselves if a reasonable, or should I say, a conclusion that shows justice has taken place. We see that justice has taken place. That's very important. And for the fact that they're going back and forth on that issue, if it should be aired real time, tells me, what are you hiding? What's the skeleton in the cupboard? What don't you want us to see? After all, it's the electorates that count. And it's the electorates that, should I say, their voices need to be heard on this matter. So that's my take on that issue.
Oh, look what you've done to me.
The Nigerian judicial system in time past has been an object of ridicule by so many Nigerians because of the kind of decisions they take. I am not a lawyer, so I wouldn't really know some of the reasons behind the decisions they take as per some judgments that were passed in time past and even recent time. But as an individual and someone who believes in the future of Nigeria, I still believe they are doing whatever they are doing in their profession as lawyers and judges. Nonetheless, there was a particular case between the last governorship election in Imo State, where Governor Hope Uzodinma was declared the winner of the election, and coming forth by the announcement of the INEC or the result of the election, he came forth. I think Right Honorable Emeka Ihedioha, who came first by the announcement, was sworn in. The case was dragged to the court. Whatever happened, I am not in the judiciary. But the fourth became the first. So some of these kind of issues can bring down people's belief that there could be fair judgment in the courts. And so many people have also lost confidence in the judiciary, because there is this popular saying that if you know like go court. So it gives whoever that is saying if you know like go court an edge, owing to the fact that if he has been able to maneuver his way from the INEC table, then court is a done deal. So they really need to do more in terms of the judgment they give, particularly as it has to do with elections. Then secondly, also there have been issues of technicalities in the judgment. I had an opportunity. I have so many lawyers friends. When a particular judgment is given, I will just drive to the offices. We'll be arguing. They'll always tell you that there are technicalities in the law. That is why it is possible somebody that took fourth can become first. It could be as a result of technicalities, technical issues. But I don't think technical issues should supersede the real issue. So they can work more on the real issue and subpedal on the technical issues. That's my opinion about the Supreme Court. The case is ongoing. I was just watching from my television when I saw breaking news: court dismisses application by PDP seeking to televise the day-to-day proceedings of the court. Why? So those of us that are not opportune to be in the court, we shouldn't see the proceedings. These are some technicalities that we don't want. Televise it. Let's see it. I can sit at the comfort of my office and I can as well follow the proceedings in the court because I am interested. So that by tomorrow nobody will come and tell me this was what happened. I will be part of it, like technically or visually. So some of these things are not necessary. And this present election that is about to be sworn in next week or in a few weeks' time has so many complained that the election was not transparent, it wasn't free, it wasn't fair. Actually, in my own opinion, what the chairman of the INEC did was like setting a time bomb waiting for an explosion. You don't announce results when people are sleeping. It's only in the Bible that the Bible said that when men were sleeping, the demon, the devil, they went and saw stars. So you don't do those kind of things when somebody is sleeping. No, it's sheer wickedness. What if Nigerians woke up the next day and they woke up into crisis? Maybe seeing breaking news, INEC has declared so person the winner of the February 25th election, presidential election. And you have been following these things. Why? There were intervals that will say, okay, let's go for break. Even if you had finished the coalition, done everything at 3 a.m., why don't you go for break and resume proceedings by 6 or 8 in the morning? These are so you tell you that if you don't like it, go to court. Go court. And we don't have confidence in the court. So if by tomorrow I see people on the street, I won't be surprised because they have lost confidence in the court. So the court still need to do a lot to regain our confidence. And to crown it all, if there were judgments that were given by the court and those judgments don't seem clearer to the populace, come up on air. Do you understand? Come up on air and tell us why this, why this was that, that by so it will ease us of the tension. Yes. But you now come and say, for so reason you have given your judgment without explaining the judgment to us. We are not all judges. We are not all lawyers. So that's my own. The Supreme Court, they still have a lot to do when it comes to fair judgment. Yes. They may be doing their best, but their best is not good enough for us. Well, I don't know. Like I said before, I am not a judge. I'm not a lawyer. But if you let me decide on how judges should be selected, that should be the business of the judiciary. Yes, it should be strictly business of the Judicial Council, not the president deciding who becomes the chief judge of the federation, because that judge can still sit on the case that has to do with you tomorrow. So what becomes of you? Do you understand? You know, like the lawyers, I mean, in the law, they say you cannot be a judge in your own case. Do you understand? And there's one other popular adage that says that when you fight somebody and the person is telling you that let us go to court, you should know that his brother is the judge. Do you understand? So, in the choice of judges, I think the National Judicial Council or any other body that controls or moderates the activities of the judiciary should be given a free hand to do that, because they are an independent body. They don't have the same budget with the executive. They don't have the same budget with the legislature. They are an arm of governance. So the choice of judges should be the business of the judicial arm, not the executive. So if you leave, for example, now, if you allow me now to come to your family, maybe your father gave birth to you 6 boys, 3 girls, and like that. You allow me to come and then choose who becomes the leader of your own house. So that, and I have a business partnership with your family. When I come for business, I will look for whoever that when I come will favor me. So I don't think it's right with the choice, the manner in which the judges are being appointed. It shouldn't be the business of the executive. Down to the state, you know, there are state judges too. You know, down to the state, the governors shouldn't be the people to appoint. They are state judicial council. They should be given free hand to choose the judges, so that there should be fairness, equity, and justice.
Well, if you can say, I would say the Supreme Court was, like every other court, was created to resolve issues, administer justice, review its laws, protect the provisions of the Constitution, shape public policy, if you may, and a whole host of issues, you know, settle disputes between parties, government bodies, even between states. I would take on, for instance, on the issue of administering justice, or if you may, settling issues. You look at the Naira design case, when certain governors approach the court, that there is a dispute between states and federal government, the federal government, and in such circumstance, generally, the Supreme Court will have a regional jurisdiction to settle the issue. And what were the issues before the court? If you look at the affidavit, it was based on the monetization of our policy. The Supreme Court, one way or the other, had to assume jurisdiction as a policy court to resolve that issue. In settling disputes, you look at the case of Hope Uzodinma Machina comes into play. When cases are brought before the courts, generally, it is the argument brought forth by the lawyers that the court will stick to. That is what will be what they are meant to decide, you know, resolve one way or the other, because in law, generally, there must be an end to litigation. So it is most times the argument advanced by the lawyers in the matter that the court would actually decide. If, for instance, the argument is whether a particular procedure adopted is the appropriate one in a particular issue, the court will stick to that. However, for the purpose of doing justice when a right has been violated, being a policy court, the court also has jurisdiction to ensure and has that power to ensure that it does justice, substantive justice to the parties involved. First, I must say that the current mode of appointment of justices, or just generally judicial officers in this country, is, in my considered opinion, is flawed. Because a person who appoints you, one way or the other, has influence over you. And I say this with the greatest of respect. If you look at it, one way or the other, the confirmation is done by the Senate, depends whether at the state level or the federal level, that's the Senate or the State House of Assembly, while the NJC is saddled with the responsibility of making that recommendation. The appointment is now done by the president or governor, as the case may be. But I feel, my perception is that such process should have nothing to do with it should not, the presidency, the executive should not concern itself with it. The entire body should be done by the NJC. They should handle their affairs, or an independent body handling that duty, that function, but not the presidency. Because take for instance, if you want to put it, when it now gets to issues that involves government, and the person who has power to appoint you also have power to determine one way or the other, dictate the tune of your function. It is on that premise that I am saying, in my considered opinion, that such appointments should not come. The judiciary should be saddled with the responsibility of handling all its processes, everything that concerns itself. Generally, the Supreme Court shapes public policy by doing substantive justice to matters brought before it. You cast our mind back to the burning issues, look at the Naira design case, monetization policy. You look at, in doing justice to that case, the Supreme Court, in assuming jurisdiction, had to make reference to the provisions of Section 20, subsection 1 and 3 of the CBN Act, by also interpreting the law as it is. And that law, of course, if you look at that case, it interpreted the law to reflect the wishes and aspirations of the people, because Nigerians were actually suffering. There was paucity of funds going around. Also, check overzealous political actions, put it into check. And you also say the issue of judicial review. Now, in doing these, the Supreme Court has, one way or the other, shapes public policy. So we would say, yes, these are the measures or ways in which the Supreme Court shapes public policy. The factors that influence the decision of the Supreme Court, the knowledge of the law, of the justice in a particular matter, disposition of the court towards that particular matter, the sensitivity of that matter, the biasness, if any, and we look at issue of corruption, because one way or the other, if a judicial officer is not upright in doing a particular matter, it may give a perverse decision which one way or the other would affect the outcome of that case. Well, my recommendations are few, and I'll say that to change the face of the judiciary, one, there should be issue of speedy, embrace speedy delivery of justice. I take the view that election petitions should be resolved at most 3 weeks after the elections have been concluded. Once elections have been concluded and parties are aggrieved to the result, any issue pertaining to that election should be resolved within 3 weeks. Issues bordering on question of law can be decided within 1 week. Even a day, sit down and say, what is the issue? Whether the 25% is required, the person is meant to have 25% from Abuja for the person to be declared winner. That issue is an issue of law. So it can be declared, can be decided in a day. You need not stay days before that, weeks and months, the way we have it now. And then the court should also embrace technology. We still have a court system where judges write longhand. In other jurisdictions, issues pertaining to recording of court proceedings are done by technology. We can embrace that, and then so that we have a fluid and speedy delivery justice system, justice delivery system, where judgments can be given within a space of 1 month. Parties have issues before the court within at most 2 weeks. They know the outcome of their fate. I think it should also be the same, without not sacrificing substantive justice. Yeah, that's my take. Thank you.
Legislature controls the national treasury and establishes regulations that govern each citizen's rights and responsibilities. In contrast, the court has no control over either the sword or the purse. It genuinely possesses neither power nor volition. It exclusively issues decisions establishing the rights and obligations of citizens and other institutions. The judiciary tasks, functions, and powers are executed by court of law and tribunals, judicial officers like justices, judges, qadis, magistrates, and other judicial professionals such as court clerks. Now, this is how the court functions. The question begs, how is the court system constitutionally structured in Nigeria? How are appointments of judges and justices in Nigeria made? We will now speak with some lawyers who would expatiate on these questions.
Between contending issues in the context of our democracy, we say it is an arm of government that arbitrates between the executive and the legislature, and between the people themselves when they have dispute among themselves, as well as the people and the government and agencies and organs of government. So it is, so to speak, the third arm of a government in a democracy, where you have the executive and the legislature. So the judiciary is there to arbitrate on disputes all round between the citizenry, the government, and between the government themselves as federal government and states, within the context of the law and the constitution. Well, the courts, first of all, there's a hierarchy of courts. Let's start from the highest court, which is the Supreme Court, down to the lowest courts, which you have For instance, in Kaduna State, you have customary courts, you have Sharia courts. Those are courts created by states. Those are the lowest rungs of the court. But from the Supreme Court, you come down to the Court of Appeal, then you come down to the High Courts of the states, the Federal High Court, the National Industrial Courts, which are all on the same level. Then you come down to the magistrate courts and the customary courts and the Sharia courts at the state level. Let's start from the lowest courts, the magistrate courts. They are principally dealing with criminal cases, even though in some jurisdictions they are combined together with what we call the district courts. Like here, the magistrate sits as a criminal judge as well as a civil judge. When he's sitting as a civil judge, he's called a district judge. But when he's sitting for criminal cases, he's called a magistrate. So there are levels of cases that can be tried at that level. There are levels that cannot be tried, criminal cases that cannot be tried by the magistrate court. They have to be taken to the high court. But majority of cases and majority of our people come into contact with the judiciary through these lower levels of the courts, because most of the cases are small cases. They go to this court, so you find that the citizenry, majority of them, come into contact with the judiciary through these lower levels of the court. The most serious cases, whether criminal or civil, end up going to the high court. But when you also find where you have Sharia court, you know there is Islamic personal law. The Sharia court also deal with them at the level of the state before you still go to the Sharia Court of Appeal in the state, from which appeals we go to the Court of Appeal. All appeals at the magistrate court or district court go to the high court of the state. If it is customary court, it goes to the customary court of the appeal. If it is Sharia court, it will go to the Sharia court of appeal of that state. But from the high court, all appeals will go to the Court of Appeal, and eventually from the Court of Appeal to the Supreme Court, which is the final court. Well, the appointment of justices and judges for the federal courts, they are made on the recommendation of the Federal Judicial Service Commission to the National Judicial Service Commission. The justices of the Supreme Court and Court of Appeal are appointed by the President on the advice of the NJC, that is the National Judicial Commission, which itself is advised by the Federal Judicial Service Commission. So it's a process initiated by the Federal Judicial Service Commission to the National Judicial Service, and they recommend the President appoint, subject to confirmation by the National Assembly. But at the state level, the State Judicial Service Commission recommends to the NJC, the National Judicial Commission, which in turn recommends to the state governors for approval, and they are also confirmed by the state houses of assembly. But the appointment of the lower cadre, like magistrates, are entirely a state affair, done with the on the advice of the State Judicial Service Commission by the state governors. That's the magistrates, the district court judges, the Sharia court judges. And the Supreme Court is not exactly a court of policy. Historically, there has been disputes and discussions on the role of courts generally and particularly the highest court in every land, whether the judiciary should be strictly an interpretative judiciary or what we call judicial activism. If we limit the court to just the interpretation of the law, then you say there's no judicial activism. They just look at what the law says according to their understanding and pronounce their judgment. They interpret the laws made by the legislature and assented to by the president. But in interpreting the law, there are always gaps here and there. And you find some judges doing what we call judicial activism by expanding or retracting from the law. That's what is called judicial activism. Where there are gaps or where the judgment can go both ways, looking at the law, you can interpret it this way or you can interpret it this way. Then the court is in a unique position to have some activism having regard to the mood of the country, the sentiments, and other issues pertaining to the country, because after all, they are also from the society. So that is principally the role of the court. But we cannot also take away from the fact that being the final court, they have a lot of leverage. They make rules, although the rules are principally for the conduct of proceedings in the Supreme Court. The Court of Appeal, each court makes its own rules. Court of Appeal makes rules for the conduct of proceedings at the Court of Appeal level. The Chief Judge of the Federal High Court makes rules for the conduct of proceedings in the Federal High Court. So also the various state High Court. But the Chief Justice of Nigeria, being in charge of the judiciary overall, has some policy direction. For instance, recently, when the issue arose of diverse ex parte orders that were conflicting, you have one ex parte order from this court, you have exactly the opposite of it in another state. The Chief Justice had to summon all the chief judges of the states and lay down some policies to help eliminate that kind of anomaly. As a matter of fact, I hope I'll have enough time, or I will try as much as possible to summarize, because it's a question that has agitated the vast majority of Nigerians, and even we that practice law. As you rightly say, the judiciary is the last hope of the common man, not just the common man, everybody, because you find that even the person that is not common will also have something that will bring you to the judiciary. So people expect the judiciary to be above board, first of all. And we have what we call the certainty of law. You are coming from a background of the certainty in the law, so that as a legal practitioner, if I am going or taking a case all the way to the Supreme Court, I know what the law is supposed to be. So I expect that by the time the Supreme Court decides, it will fit into that certainty that you have learned even as a student in the university and the law school and while you are practicing. Now, recently, there has been a lot of criticism, let me put it that way, of the Supreme Court in particular and the judiciary at large. And there is some good reason for us to be agitated and to be alarmed at what has been happening. Normally, I would, as a lawyer, be defending be first out of the block to be defending the judiciary and the Supreme Court. But we have become cautious, and we are not quite forthright in defending the judiciary because of certain judgments that have been made. Like I said, there is certainty in law, but when that certainty appears not to be there anymore, the only outcome would be confusion. You mentioned the case of the Senate President. If I were to dwell on this and give a background, I will go back a little bit. When, in my opinion, things started going bad, or things started getting awry for the Supreme Court. If you recall the case of Atiku Abubakar, when he was vice president, and he left the party that sponsored him to power and embraced another party. And the Supreme Court held that he could remain in office while he had decamped from the party that brought him to power. To me, I felt that that was when things started getting wrong for the Supreme Court. And you have to ask yourself, the Constitution says if you want to contest for president, you have to nominate an associate from the same political party with you, who will run with you as your vice president. That's the reason for that. The parties canvass for votes from the electorate based on their manifestos, based on what they want to do, which we put it in a manifesto. And then you go into the election. You have the electorate prefer one manifesto against another, and they vote them into power. Then you have the person that has been voted now leaving what the electorate preferred, what the electorate chose, the kind of manifesto and programs the electorate chose to embrace one that was rejected by the electorate. And the Supreme Court will say he remains in that office with the possibility that he will become the president if something happens to the president and carry out an agenda or a manifesto that was rejected by the electorate. I thought that was something that started to affect our politics. It did not help our politics in Nigeria. And it gave rise to, if the Supreme Court had put their foot down at that point, probably most of these decampings you see left and right would not have gone to that extent. So I saw it as part of the time when things started going wrong at the highest court. They moved from there to Amechi's case, where elections took place. People campaigned, went round and presented themselves to the electorate, and then an election was conducted. And for the fact that you now come and say, no, this was the candidate of the PDP, Amechi was the rightful candidate, but elections had already happened. He had not gone to anywhere. He had not gone to the electorate to present himself to campaign. Then you now deem him to have been the person who contested the election. I criticize that judgment because in law, we don't deem what has already happened. We prove it. If an incident has already happened here, we prove it. We don't deem it. We prove what happened. We prove who contested the election. But because of what happened in Imo State, in Ararume's case, one could understand the sentiment that brought about the judgment in Amechi's case. But it did not help our politics. It did not help our democracy. We do not want the Supreme Court to be the ones appointing our rulers. Let the electorate vote the people of their choice. I took it that it was the Supreme Court that appointed Amechi as governor. That's my own opinion. The Chief Judge of the Federal High Court made practice directions to enable pre-election matters to be heard speedily. Because if you use the usual rules of court, they will not apply because the pre-election matters are time-bound. The Federal High Court is to complete hearing of them within 180 days. The Court of Appeal is to decide within 60 days. So also the Supreme Court within. So if you use the times provided by and the procedures provided in the normal rules, it will not work. So the Chief Judge made practice directions for pre-election matters, and they only provided for originating summons. Now, originating summons is a procedure where you only interpret documents or laws. There's no serious dispute on the facts. That's the modality of originating summons. So we all filed pre-election matters following or using that originating summons. The case of Machina also followed the same pattern. Now, the whole country, everybody knows, and we have something we call judicial notice, that the courts, without even being brought to their attention, they can take judicial notice of certain happenings in the country, which are notorious. We know that the presidential primaries of each party came after the primaries for National Assembly seats, like Senate and House of Reps. They started down and went up. The final primary was for presidential candidate. And everybody knows that the Senate president did not participate in the senatorial primary of his party, which happened before the presidential, because he was contesting in the presidential primary. Now, by the Electoral Act, you can only emerge from a primary. The situation where the parties could bring anybody has been taken care of by the current 22 Electoral Act. You must emerge from a lawfully conducted primary. Now, after the senatorial primary of the APC in Borno State, Machina emerged. Lawan did not contest. Machina emerged. Then they went into the final primary to nominate the party's presidential candidate, and Lawan lost. We are all aware of the interest that followed when he wanted to get back the seat by trying to get Machina to withdraw voluntarily, which will give him an avenue for the party to conduct a fresh primary where he can emerge. But he refused. We are aware that letters were written purportedly by Machina to INEC that he had withdrawn, but he countered them. So this is the situation where the APC went ahead and purported to conduct another primary where Lawan emerged, and they forwarded his name to INEC as the party's candidate. The matter went to Federal High Court, and the Federal High Court ruled against him. He went to Court of Appeal, and the Court of Appeal, rightly in my view, also heard that Machina was the appropriate candidate. It was the party itself that appealed to the Supreme Court. Now, the only reason the Supreme Court allowed the appeal was that the initiation of the process at the Federal High Court by originating summons was wrong, because the facts were disputed. But they did not go ahead to rule on the power of the Chief Judge to make those practice directions, which we made, under which the pre-election matters were fired. And it was also a bit too late in the day to come to the Supreme Court to raise the issue that ought to have been raised at the Federal High Court, knowing that if the Supreme Court were going to say in normal cases where you institute a suit by a wrong procedure, it will be converted to the right procedure. But this is not normal because the time within which the Constitution prescribed for the case had already elapsed. So there was no way you can say, okay, this case was brought by the wrong procedure, go and do it in the right way. But by focusing on that, they denied Machina the justice that he deserved, rightfully. And that was the only reason. They did not go into the merit of the case, whether Lawan participated in a primary or not. They did not consider any other issue. Once they came to the conclusion that the initiation of the process at the Federal High Court was by a wrong procedure, they terminated the case at the Federal High Court level. So what now happened was that what was left with was that APC had already sent the name of Lawan to INEC. So it stood. Because there was nothing from the court challenging it. That was an unfortunate, very, very unfortunate development, which by and large, nobody is happy with. And me as a lawyer, I cannot defend that judgment because it does not, one, help our democracy. Two, we used to say that justice should not just be done. It must be seen to be done. In other words, a layman who is not a lawyer, who is in the court, hearing or seeing what has happened, what impression does he go away with? Does he go away with just I've seen justice done or I've seen injustice done? That is a cardinal principle of law, that justice must not only be done, must be seen to be done. So, in some cases, you hear the Supreme Court say, we will not dwell too much on technicalities. We will do substantial justice. In this case, that principle failed. Substantial justice was not done. Lawan had no business being in the context of the senatorial race.
Now, we shall look at why the Supreme Court is called a court of policy.